I always recommend getting an appraisal. I always think that an appraisal is helpful because going back and getting that information is more difficult than getting the information up front. But if there's, like, let's say that there's one parent, two children, and both of them are inheriting a house and they want to agree on a price for that house, I'm not going to require them to go get an appraisal for them to enter into this agreement. The reason why I would say to get an appraisal, though, is because Arizona does have a step up in basis, meaning that when you inherit a property, you inherit that property at the value it is as of the date of death. And so you want to make sure that you're protected when you go to sell that property.
Hey guys, welcome back to the Probate House Guy podcast. I am Brad Woodall, the Probate House Guy, and today we're continuing our series where we're getting a probate attorney or an estate attorney from all 50 states to answer questions for their specific state, because probate's very kind of state specific. So today I've got two attorneys on the podcast from Arizona, the hot, scorching state of Arizona this time of year. So I've got Elizabeth Cole and David. So why don't you guys, Elizabeth, why don't you introduce yourself?
Thank you for having me. My name is Elizabeth. I have been practicing in this area for several years now. Probate in Arizona is a really interesting process, and so I'm happy to be here, but my background is mostly in litigation. So David and I work tandem. We work side by side on a lot of cases because I do the things that are in court and David does the things that are out of court.
Cool. And David, why don't you tell us about yourself?
Yeah, welcome. My name is David Gerszewski. I'm the principal at the Citadel Law Firm in Chandler, Arizona. I'm a second career attorney. For my first 20 years, I was a Wall Street guy, 10 years at the big investment banks as a proprietary trader, doing derivatives in emerging markets. And for the remainder of that time, I had a private hedge fund in London that we started from zero in 2003, built it up to about $3 billion of assets under management. I was turning 40, still single, never married, no kids, left the farm in North Dakota when I was 18 and hadn't seen my parents much. So I just decided to walk away from it and do something else. So moved to Arizona. Parents were around the corner. I suck at golf. I'm going to work till I die. And somebody dared me to go to law school. And I met a tax professor and I discovered this wonderful area of practice. Coming out of law school 9 years ago in 2015, I immediately set up shop. I've since narrowed my scope. I do exclusively pre-death estate planning for competent individuals, those who have capacity. And parallel to this, I have a registered investment advisory business, and we do asset management, stocks and bonds, retirement income planning, financial planning.
Awesome. Well, that's quite a resume you got there, David. That's cool. A lot of our audience is real estate investors, right? So I'm sure they'll be happy to hear some of the tips you might have about doing estate planning, because, you know, when you've got a lot of real estate holdings, you better be planning for that in case you pass. Life's not guaranteed to us, that's for sure. Mm-hmm. So how did you kind of briefly talked, David, on how you got into the estate law world. Like, what made you want to go that route? I know you said you stumbled upon it. What made you kind of go that route?
The truth is, I went to law school because I was bored in my mid-40s. And I met a tax professor, took all of his classes. And about 10 minutes after my bar results posted online, I got a phone call on my cell phone, and he invited me to come and work for him. I wasn't sure I wanted to commute an hour every day, so we agreed that I would go there for 6 months and I'd make a decision then. And my decision was, having seen his practice, I loved the area of law. I was fascinated with it. But at my age and with my previous background, I really wanted to be a business owner myself. So really immediately set up shop and started building a clientele that way.
Okay, awesome. And you've kind of bootstrapped that since and built it up to something that gives you a fun life, right? I'm assuming?
You know, we still work about 60 to 70 hours a week. I mean, maybe someday we'll thin it down to 55. But the truth is, if you love what you do, it's really not work. You know, we're helping people every day. And unlike my previous career that was very institutional, we get to serve individuals every day and make their lives better and help their families. And it's just a joy to be able to do that.
That's so cool. Love it. And Elizabeth, so you were in litigation before, and off the call, you had mentioned kind of what you did before. So what got you into the probate estate realm? Like, what made you kind of make the switch?
It's so interesting because when I went to law school, I swore I would never work in this area. I thought it's just so boring. It just seems so dull to me. I have no interest in this. I really want to do litigation, and my focus was on a vulnerable population. I worked with juveniles, and I felt like I was going to be in that area forever. And I transitioned from helping one vulnerable population and moved over to another vulnerable population. So now I'm working with the elderly. And typically I help families when they're in the middle of kind of a crisis. So people are coming to me in some of the worst situations they've ever been in. A loved one, a family member, somebody has lost capacity. They need help with their daily acts of living. They need help managing their assets, and they need someone to step in and do these types of things. So I get to come in those areas, and I get to provide that assistance to these family members, these loved ones that need aid. And then I also get to help with trust administrations, and those can be before someone has passed away, when they maybe don't want to manage their assets anymore, and maybe they do have capacity and they just want to hand it off, or they have passed away. And so I get to deal with kind of pre-death and post-death for families that need someone to step in, and I get to go through the probate process with these family members who, again, they're still going through some of the worst situations in their lives, people that they love, people that they're close to have passed away. And so I agree with David. I really like this area of the law, that I get to help people every single day. I feel a lot of benefit from working in this area because people get immediate relief. They get someone to step in and help working to quickly resolve the issue.
And for so many people, I mean, I've in the real estate space, I've been focusing in the kind of probate niche for years. And I learned very early on that these kind of deals are not about the real estate. It's about the family in crisis that has obviously dealt with the death of a loved one, and now they're dealing with that. We've also dealt with people that maybe are in assisted living, or, you know, they have a power of attorney or something like that, and the family needs to sell a real estate asset to pay for assisted living, because it isn't cheap, that's for sure. And they need help, and they don't know, because this is so complicated, and they need somebody to guide them and help them. And there's so many charlatans, and just as in the real estate world, there are in the legal world, that will not probably do the best job at helping them with these things, and then it ends up creating a bigger mess, you know? So that's great.
It does. Some of my favorite clients are the ones that meet with me in the very beginning, where they say, this is the situation I'm dealing with, and this has been a very new happenstance. I need aid, and I'm noticing these things, and can we put things in place? But to be honest, the majority of my clients are coming to me in crisis. Either the house is going to a trustee sale, or we have a family member who they really need aid immediately. They should have moved out of their house a long time ago, and we don't have access to their funds. And so it's a bit of a crisis. And dealing with a situation when people are in crisis, certainly I'm available to help. I can absolutely step in that situation and help you resolve it. But it's definitely easier when you've reached out for help in the beginning and have said, I'm noticing these things. I'm becoming familiar that this person is changing. They're not really controlling the things that I've seen them historically do. What should I be doing in terms of planning? Those are the situations where I feel like, thank you for calling, and we can certainly get you on that path.
Yeah, it was funny. I was talking to my dad on the phone the other day, and he was talking to his dad the other day and was like, hey, Dad, like, you're 87 years old now. Like, we need to start thinking about, like, what's going to happen. Like, I mean, the reality is you don't have that much more. I mean, you're healthy today, right? And that's great. And that's awesome. But, like, it could change. Like, for instance, my 93-year-old grandfather just passed away in March. Like, he lived an awesome life, and, you know, but the last few years he started declining. So, like, you know, hopefully people talk to people like David first, right, and plan ahead. But the reality is most Americans don't. And then they come to someone like you who's like, okay, pick up the pieces, fix this for me, right? So
Definitely.
What would you guys say are the biggest mistakes that you see people make in general? Maybe like top 3 mistakes they make with their estates and their estate planning.
Sure. Well, you know, they kind of niche down into really a few categories. I would say the first biggest one is procrastination. People wait to a point until they need Elizabeth, or they just don't do anything at all. And about 70% of the population, give or take, depending on what statistics you're using, die with nothing in place, and they just leave a firestorm for their family in the midst when they die. And oftentimes when people like Elizabeth get involved, but even before they die. The second big category is the do-it-yourself planning. They'll go to a couple of the big well-known websites. They download a form because it's cheap, and they'll just put something together because their neighbor or their friend or they heard something on a radio talk show say, well, just do this. You really don't need to plan for this. You can figure it out yourself. We're finishing up a case next week. The gentleman decided to do his own will with a downloadable form for a website. Mm-hmm. What would have been maybe a $5,000 6-month probate has turned into a $24,000 3-year probate. And he's left his family with a mess. During the probate, some of the beneficiaries have died. It's just been a firestorm. And then the third thing is really the one-size-fits-all approach. And I'm gonna criticize some of my attorney colleagues that, frankly, this is a business. There are a couple of different ways to approach it. In Arizona, in our market, you hear a lot of, you must get a revocable living trust. You need a revocable living trust. It's everywhere. Avoid probate. You don't want to go through probate. And the truth is, there's kind of this, as I refer to it, as a McDonald's approach to this practice of law. You're really concerned about a couple of questions. Are you single or are you married? How many children do you have? And I call that McDonald's because it's really, do you want a hamburger or a cheeseburger and how many pickles? And that is much more of an assembly line approach to business. The people that are getting the plan now are really just getting the same plan with different names from the people who were sitting in those chairs 2 hours ago. And that one-size DIY approach, one-size-fits-all approach, really results in Elizabeth having to get involved in more complex stuff on the back end because it's not appropriate. What I've found from the last 10 years that I've been doing this is, number one, avoid the procrastination, call someone who does this area of law, don't do it yourself, and find someone who approaches your meeting to be designed just for you. The way we look at it is someone comes in, we interview them. In that first hour, we try to find out which chassis do you fit in. Our law firm, we've identified 14 chassis, and then we build their estate plan on top of that chassis, and that minimizes the back end work and then the family strife that comes along with, father time.
Sure. I mean, every situation is unique, and I've done a lot of videos about this where I tell people, it's like, look, just because what worked for that guy doesn't mean it's going to work for you. And then as you get into individuals, which I'm sure you deal with, David, that are higher net worth individuals, where you guys are in Arizona, obviously it's a kind of wealthy part of town, right? The more assets you acquire, the more complicated your estate planning has to be. And when you own businesses and you have employees like myself, I have to make plans for, what happens if I die? Who can run payroll? Like what, all that sort of stuff, right? All that has to be thought about. Or business partnerships. What if one partner dies? How does the other one buy them out? Like there's so many moving parts to this.
As with everything, you really need to find the professional that's appropriate for you. In our area of work, we'll meet a lot of people and they'll be like, my financial advisor said to do this. And that's fine. A lot of the advice, it might be relevant, but it's not particularly relevant. And sometimes the motivations of those people are really to keep their clients closer to themselves. If you have a great financial advisor, that is an amazing asset to have on your side. But by the same token, if you need a cardiologist, you're not going to go to your podiatrist, right? If you blow through the stop sign and take out a little kid, you're probably going to call the criminal lawyer, not your estate lawyer or financial advisor. And the important thing that we really see is find the right professional to solve the particular problem, whether that's a real estate problem, a legal problem, a medical problem. Find someone with a niche. The attorneys who do bankruptcy, marijuana law, estate planning, guardianships, that's generally just a snowball telling you that someone really doesn't have a sound practice, so they take anything that comes in the door.
Yeah, and that's kind of the way, like when I rehab houses, right? And some people are like, oh, hire a general contractor. No, I have trades and all my subs do very specific tasks. And I don't just pick one general person. I knew this guy's really good at tile. I knew this guy's good at tile in a really high-end house. This guy I'll put a low-end house. Like I have people that I put in different slots that have specific areas of specialty, and I bring them in when I need them, and they know their specific thing, and they're really good at that. And it's the same like you're talking about, right?
Absolutely. Yeah.
If you need something like, for instance, my CPA only does real estate investor clients. All of his clients are just real estate investors. He knows the tax code around real estate better than anybody else, right? And that's why I use him to do my taxes and not my buddy that owns a trucking company, right? I don't use his CPA.
That's right.
Exactly. So this is probably a question for you, Elizabeth. In Arizona, when you do have to probate an estate, how long does that typically take? Kind of best case scenario, average, and worst case scenario. Like what is that in Arizona? How long does that usually take?
So the best case scenario is somebody who has kept up on their taxes. They have their documents organized. I don't need you to provide a list of all of the assets that you own and where they are, but I do need you to have some of your documents accessible. I need your kids or loved ones to know what your estate contains, if that's property, if that's bank accounts, if that's investments, what that looks like. In the best case scenario, I usually prep my clients that it's going to take at least a year. Most of them are between 18 months and 2 years. And the reason for that is because you have to follow an order of operations in Arizona. And typically the thing that's going to take the most time is resolving issues with creditors. If there's a business in there, that's going to take a bit longer oftentimes, and especially handling tax issues. When you're dealing with a loved one and maybe people haven't stayed on top of that person, we don't have a power of attorney, nobody's been checking in on them, we usually find that they haven't done their taxes in a number of years. And if you have to go back and do all of those things, it can take a long time to collect those documents, review all of it, get everything organized. And those things have to be done before you do a final distribution. In the best case scenario for a trust administration, I would still say probably a year. For somebody who's been on top of their stuff and they get their taxes done right away and they get all of the things organized and this person has done their due diligence, we don't even need a probate. I can get that done in probably 6 to 9 months in just, it has to be a pristine case. The majority are not. I don't have many clients that are in that window.
Okay. And now you're saying full time, is that from opening a state to closing a state? Because most of the people, right, they think of probate in the terms of when can I sell that house and when can I get money in my bank account, right? Versus, obviously, eventually you're filing a tax return and doing all the accountings and all that stuff. So from let's say when they petition to open a probate to when they can sell mom's house and give money to everybody in their family in Arizona, what's that timeline typically like?
Okay, so Arizona has 2 different avenues that you can take depending on what your circumstances look like. There's an informal route, and the informal route means you don't have to go through the courts at all. You can go through the registrar's office. In there, it really depends on the court that you're in, right? Coconino County, Yavapai County, Pinal County, some of those are taking between 6 weeks for the registrars to look at those documents and get your letters issued. If you have to go the formal route, that usually means you're missing some type of documentation. You can't get a hold of an heir. There are just a couple of things that we want to run through a judge first and make sure that a judge is involved in that situation. That involves getting a court hearing. And the majority of courts around Arizona right now are taking probably 8 to 12 weeks to schedule that initial hearing. And so from both of those circumstances, what you need to sell the property is you need authority. And in Arizona, a lot of people think I have a will, I'm nominated in the will, my name is here, this is enough. It's not. Yep. You really need to be authorized, and the will needs to be probated so that you can get that authority. So you have to go through either the registrar's office informally or the courts formally. And then once you have your letters of personal representative, you can move forward with actually selling the property. Some people, if they've been living in that property, I have a case right now where the woman and her husband were looking to sell the home, and they were in the middle of getting the house sold, and the husband passed away, which is just terrible. They have a buyer lined up, everything was ready to go, and they said, we just can't do anything without letters. You can put the house on the market, you can get the house touring, all of those kinds of things if you already had access to the property, if it's something that you are familiar with. But you can't sell the property until you have letters of personal representative. You have all of... Oh, go ahead,
right.
David.
No, I was just going to piggyback on that briefly. I think one of the biggest misconceptions I see with people who've maybe done the estate planning process or unfortunately maybe have gone through a McDonald's-style approach with an attorney, they don't really understand what the elements of their estate plan are, those particular parts of the portfolio. And the biggest misconception is actually with the last will. As Elizabeth says, a lot of people think that that's what they need. What actually a will is, it's evidence in a probate proceeding. It's your last will, a statement of your desires, and testament, your testimony from beyond the grave. And people don't understand that very critical mechanism. Wherever they learned what a will was, they didn't understand its purpose, I think. I don't know, do you agree with that, Elizabeth?
I do agree with that. A lot of people really just think that that's reliable in and of itself. And oftentimes it is, but we need the courts to authenticate that. We need the courts to review it and to agree with you. And we need to give all of the members that are, heirs, beneficiaries, the people that are included within this estate, we need to give them the opportunity to speak their mind as well. And so you can't just run off with this document that you believe is what it is without actually getting the courts involved in that. And so it is an important step. And I think a lot of people overlook that.
And you mentioned this earlier, you mentioned the creditors, right? Like a lot of people think, they don't realize that the creditors have to get paid first before the heirs can take any distributions from the estate. So a lot of states, like I live in Georgia, we have a notice to creditors period where you have to publish a publication and it has to run for so long, and it gives those creditors a certain amount of time to come forward and say, Johnny owes us $10,000 and whatever. And you can't take any money out of the estate until that period's over with. So I'm assuming Arizona has something similar because you mentioned that earlier. So
yeah, Arizona does. They have a 4-month waiting period for the creditor period. And I understand people want to get to the money. People want that money to be distributed. I completely understand that. But what I will say is that you maybe don't know your family member as well as you think you do. And then when you're going through probate, you find there are just some things going on that maybe you weren't aware of, some bills that went unpaid. Again, if you have an issue with taxes, sometimes you have some back taxes that need to be paid. I've had some people where they racked up tons and tons and tons and tons of credit card debt that the family was completely unaware of. And those are just things that you maybe can't anticipate. I have a lot of clients who ask like, well, there's over $1 million in this estate. Can't we just distribute? Can we do a partial distribution? Can we do these things? And I'm just really hard about it. I say, no, I'm sorry. I'm just not going to do it. I'm not going to have you guys take some of the money out of the estate and then find a skeleton in this person's closet. It happens more often than you think. And I like to have everything in that bucket so that we know exactly what we're dealing with. And then we go through the distribution process.
Yeah, because the creditor could sue for that. Like they can say,
certainly.
I was owed money and you took money beforehand. Like that's my money.
Yeah.
You owe me that. And then you're in litigation. And then it's like a whole nother mess, right? So
yeah,
that's crazy. Yeah, I've seen some crazy stuff. IRS, I think the most I've ever seen owed to the IRS on one property was like $750,000, and the house was only worth like $4 million. Like, I mean, eventually the house the bank took it back, and the IRS, but it was crazy. At $750,000 in IRS.
We handled a probate case in our office 2 years ago, and the family, the personal representative who was representing the family in the probate to liquidate the home, and they were ready to go. They thought they had everything organized. And 3 days before the creditor's notice window closed, we got a claim from a hospital for $1.4 million against a $700,000 estate.
Yep.
Had they done that distribution and gone out and bought new boats and cars and paid down their 3% mortgages, that hospital would have sued all of them and taken that back and really ruined their lives, because in the end, the estate was insolvent. The hospital only got half their money, but they wanted to violate Elizabeth's advice right there. And I'm like, you need to work with a real estate professional and you need to work with a probate attorney to make sure that you, as the personal representative representing the estate, don't ultimately shortchange all your family members, because they're going to make financial decisions based on those distributions. Make sure you do it right.
Yep. I've seen it time and time again. They start counting their money before they get it, and then they get disappointed when all of a sudden a creditor comes forward, or, their mom owed, the water company $10,000 and it shows up 2 days before closing and they're like, what the heck? And it's like, sorry, like this just,
This is the law.
why this exists.
Yeah.
So, and typically speaking, for in Arizona, from a probate perspective, obviously estate planning is a whole different ballgame. What would you say is typical cost, like on the low end, average, and high? High. I mean, it could be super expensive, but what does that typically cost to hire a competent attorney to do your probate in Arizona?
So I think different attorneys charge different rates. For the most part, I like to do kind of a mixed fee schedule because in probates, you can't always anticipate the things that are going to come up. I know a lot of probate attorneys are only willing to do hourly because you can't anticipate all of the things that are going to happen. But for the most part, I find that a lot of my probates are straightforward. And so I do a flat rate for that of $2,500. I also charge an additional $1,000 that I hold as a retainer in case we need to do additional things down the line. If you want to do a life estate deed for family members that are residing in the home and we need to create that deed, and that's not typically a part of the package, disclaimer deeds and dealing with some creditor issues, having to reach out to businesses and the partners to try and force them to give me their records and give me their information. Some of those things are outside the scope of what I would typically do for a straightforward probate. And so obviously I talk to my clients about that beforehand. For formal probates and for trust administrations, I usually only do those hourly. And the reason for that is because in those situations, I mean this with all due respect, I have no idea how much handholding you're going to need. I meet clients where they are, tell me what to do. I will go do it. Thank you for your letter. This is enough instruction. And I'm happy to give you a refund at the end of the probate, at the end of the trust admin. If you don't need me, you don't need me. I'm here to make sure that what you're doing is right. But I deal with a lot of people who they check in on every little thing. They want to call me about every single thing. They want me on the phone with their banker. They want me on the phone with all of these things. And so you can't always anticipate that. And I have to make sure that I'm billing for my time and that I'm taking care of what I need to take care of for my business. And so I really only do those hourly. But for a straightforward probate, typically when you're not dealing with a litany of issues, we can get that done pretty affordably, I think.
I think that's probably the number one hurdle we see. And I've bought houses and I've paid for people's probates because they really just couldn't afford it. And then my attorney and whatever agreed to get reimbursed at closing. We secure some liens on the property or whatever to ensure that it does get paid back. But some people are just like, they're like, oh my gosh, people don't even probate because they can't afford it. And then it's like, well, now you're only creating, I've seen multiple generations of families who've never probated. And then the granddaughter comes to us and wants to sell grandma's house. And I'm like, we got to probate like 3 estates now. Sorry. So for stuff like that, it sounds like you have a retainer. And does your firm do any sort of like kind of portion of the estate, percentage of the estate get paid later kind of thing? Or is that, I know there's some attorneys that do that, some don't.
Percentage of the estate, I more so am familiar with that happening in California. We don't really do that in Arizona. At least as far as I'm aware. David, feel free to correct me.
No, that was changed about 30 years ago. Yeah, we even got rid of it.
Yeah, I was like, I don't think so. There are some cases where we're familiar with families that are going through crises. And so if you really can't afford it and we need to get you out of this situation, we will do the best that we can to work with you price-wise and do what we need to do in terms of getting things on the back end if we're going to be selling a property and collecting that information. So half up front. There are things that we can do to step in and help out those situations, definitely.
Definitely. And if anybody's like concerned about that, you can work with the attorney. If you're selling to like a well-known investor like me, I've paid for people's probate, sort of advanced the money for them, knowing that I would get reimbursed on the backside. Now I've had people, I've paid for their probate and then they went around behind my back and sold the property to someone else. And then I was out thousands of dollars. That's a risk I have to take sometimes. And that's a situation basis. But if you guys if someone's coming to you to work with you, and this is a question for both of you, what tips do you have for them to make that process go smoother? What should they have ahead of time? Like how do you work smoother? Because some people, they get into things and they're handholder people or whatever. What tips do you have to just make the process go easier?
When we're working with clients, we really want to educate them, and especially on the pre-death side and the planning side. you need to make sure the professional with whom you're working is educating you about what they're doing and why. They're not just having you sign here and put up some forms. So when a client will typically call our office on the estate planning side, the pre-death side, we have staff members that coach them through our process so they understand what we do and make sure that they're an appropriate client for us. If someone's looking for the McDonald's type plan, we just tell them up front, we're probably not the best person for you because we can't do the type of work we do at the price you're looking for, which is a McDonald's type plan. The next thing we do when they schedule the appointment with us, everyone gets a questionnaire. It's not overwhelming. It's about 15, 20 minutes. They might not even know how to answer every question, but we encourage them to go through that because when it's an individual, when it's someone representing a family, maybe it's one spouse who's making the appointment for a married couple, it will trigger questions for them to answer or to at least discuss before they come in with us, and then they'll know what questions to ask. So the biggest thing for us coming in is prepping them for our process, because it absolutely is a process, and have them understand what questions beforehand so we can make our time together more productive.
Okay, cool. And Elizabeth, do you have any tips on, if someone's coming to you, what would make that process go smoother?
I think for me, my easiest cases are families that have already come together and collaborated on how best to move forward with this. The family members that know who is competent, who is responsible, who is diligent, who will manage this appropriately. It's the families where they've been in contact and they're able to go through the informal process because people are signing waivers and people are in agreement with waiving bond, and we're able to move forward collaboratively. It's the families where we haven't seen this person in years. All of this family is disconnected. I have a niece on one of my cases right now who is dealing with the probate for her aunt. And aunt has numerous siblings that are all over the United States, and they are all estranged. And there's no way that we're going to get waivers from all of these people. And the niece is trying to reconnect them, and nobody wants to be involved in that process. It makes things really difficult when families are unable to come together. It makes things more expensive. It makes things costly. The other thing that I find is really difficult is, and this is kind of hard, it's a hard pill to swallow. If your family member hasn't done a good job managing their own finances, and if they haven't taken care of themselves, and if they don't appear responsible in their everyday life, giving them a chance to be a personal representative is probably not the best move. Having to fix the issues down the line, having to undo the things that they've done, that becomes really difficult in the probate courts. So getting the right person put in as personal representative first and foremost is going to make things cheaper, smoother, easier for every person involved. Getting that brother who is just bulldozing his way through it and saying, I want this, so I'm going to do it, when everybody's looking around going, this is not a good fit, but you know what? He wants it most, is not really going to be a good idea when it comes to getting a probate resolved and wrapped up timely and affordably, in my opinion.
And that's why they have bonds for administrators, right? So that when someone screws up, and I've seen it happen, somebody's got to pay for that, right? There's it's an insurance policy for somebody being irresponsible. So yeah, that's great. Awesome. And if you, in Arizona, some states have this, some states don't. Is there a way that a family could sell a property outside of probate? Like, for example, some states have like affidavits of heirship and that sort of thing. In Georgia, we have basically if it's been less than 3 years, you have to probate. If it's been more than 3 years, there's some affidavits of descent and things you can file. Does Arizona have something similar like that?
Yeah. Arizona has an affidavit for the transfer of real property. We don't see it used often because Arizona has a $100,000 cap to use that. Number one, you have to wait 6 months after the decedent has passed away. And then the value has to be under $100,000. You just don't find a lot of property in those situations that's going to meet those parameters. And I don't find a lot of family members who are in contact with me, they're working with me, and they say, you know what, yeah, I just don't want to do anything with this property for 6 months. I'll keep paying for it. I'll keep maintaining it. I'll keep doing all of those things. But in the meantime, I'll just sit on my hands. I typically find that families want to move forward with getting this process rolling. They want the authority to be able to sell the property if they don't want to pay for it. And again, we just don't deal with properties that are that value. So I don't find that utilized a lot.
Okay, that's interesting. Yeah, I miss the glory days of being able to buy houses for less than 100 grand. That just doesn't happen anymore.
I know.
Legislation hasn't kept up with inflation. So.
That's right.
No.
The only things I could buy less than 100 grand nowadays are mobile homes, which I do invest in those, and they are good money. But that's about the only thing less than 100 grand nowadays. So yeah, I could see that. Now, obviously, I don't recommend people do this, and you probably don't recommend people do this. But in Arizona, can someone do a probate themselves? Like, are you allowed to do that? I know there's different states have different laws, but what about in Arizona? What's that look like?
I tell all of my clients, you can probably do an informal probate by yourself. The thing that my clients realize is that when they go and they actually look at the instruction, they realize that it actually makes more sense to pay someone to do this on their behalf than to spend the time learning how to do this correctly, getting all of the documents done right, getting them filed appropriately, getting the authority that you need, and then what's my next step? How do I act on this? What do I need to do? And so the majority of them, if they want to do it themselves, I'm happy to give you the instructions for how to do it yourself. But I will say the majority of those people come back to me and say, I looked into it, I tried it, please do this for me. I don't want to have to figure out all of these mechanisms, because the amount of time that it will actually take you to learn how to do this properly is time that can be well spent doing anything else. And I find that my clients really feel the benefit of working with an attorney that can guide them and direct them and take the brunt and the stress of making sure that these things are done, the accountability of having an attorney check in on you and make sure that the T's are crossed, the I's are dotted, all of the things are put in place. They really find the benefit of that. But for the people that want to DIY it, if it's a really small estate and you want to try and do it on your own, most of the courts in Arizona have those documents on there. But again, I want to tack on my warning. It is much more expensive to undo it. It is much more expensive to clean it up. Yeah. And so if you're dealing with any estate where you just feel like maybe I should get someone involved and get someone involved up front.
Definitely. Yeah. I mean, that's what I tell everyone. It's like, I mean, you can, but you know,
I wouldn't. When it comes to legal matters, I'm a lawyer, and I wouldn't try and figure out a brand new legal matter. I would hire a lawyer that's familiar with that matter. And that's coming from an attorney that has historically learned law, learned how to do different things. Hire a lawyer. Let them do it for you.
Right, right. I know everybody sees attorneys as these vicious, evil people, but the reality is there's a lot of really good attorneys they're really good in their niche, and they really love people, and they actually got into law because they want to help people. Like, they want to help. So that's awesome. So, and on that note, you know, we were talking about doing stuff yourself. Are there any like kind of shortcuts or bypasses through probate in Arizona? Like, maybe somebody didn't have any assets, they just had a car, or like kind of they call it small estates in certain states. Does Arizona have something similar to that?
Yeah, Arizona has a small estate affidavit. You can use the small estate affidavit when it comes to transferring tangible personal property, paintings, jewelry, those types of things where you need to transfer ownership, cars. I would typically say if you're dealing with a car, you should do it directly through the local DMV. And not use a small estate affidavit. Again, get an attorney involved in that, because we can remove some of the headache of trying to do those things yourself. The caveat with the small estate affidavit is that the total value of all of the assets has to be under $75,000. I have people who come to me and they say, I have a car, it's $10,000. I have another car, it's $10,000. I have a bank account that's $50,000, and I have another bank account that's $20,000. Well, why can't I use small estate affidavits separately for all of these? The caveat for using a small estate affidavit is that you sign off, you swear under oath that the total value of all of the things you're using this for is under $75,000. So I wouldn't risk it. I wouldn't do it. I'm not ever going to advise someone to sneak around that process. I would just do a probate.
Sure. Yeah. And I mean, it sounds like probate's not, in Arizona, it sounds like it's about on par with most other states. I mean, you know, if it's a small estate, it's, you know, it's going to be a few months. And the reality is most people like don't even really get started with that whole thing until a couple months after the death anyways, because there's grieving and mourning and all the things, and it takes a while to get everything together. So, I mean, I get it. We already talked about the creditors period. And we mentioned insolvent estates. If an estate, if they know ahead of time it's going to be insolvent, is it even worth their time to even go down the road to probate an estate? I mean, I've come across those cases where people have been like, look, we know dad owed the IRS, $1 million or whatever. Like, is it even, I mean, why would they need to probate in some of that, like those cases, or is it even worth their time? Like, what would you say on something like that?
On those cases, I think that they are really specific. It really depends on what the situation is with the family. For some of them, you're dealing with blended families. And so you have half of the family that are children from the decedent, and then you have a new spouse that's involved in that family. And so looking at it from that perspective of what is the actual ownership, who's living in the property, what's happening with that property. I don't know that I have a one size fits all answer on those, because sometimes it does make sense to move forward with a probate and be able to disclaim your share and get those things managed appropriately, rather than just throwing your hands up and saying, I don't want to deal with it, especially for back tax issues and those types of things. So in my opinion, it really depends. I don't know if David, you have another opinion on that.
I would agree that each of those cases is always fact specific. And I think one of the facts that we look at when we've seen those is what's in the estate, and is there any sentimental kind of multi-generational family value to maybe a particular asset, usually real estate. If there's some type of a homestead or a property or something that's multi-generational, then it might pay to actually open a probate for an insolvent estate, sell the property at fair market value, maybe on a competitive bidding process. I leave that to the real estate professionals there, like
Sure.
Bob, Brad, to organize.
Yeah.
But within that framework, maybe you can keep that asset in the family that great-granddaddy homesteaded or something like that. And that liquidity that's generated goes back into the estate to pay the creditors their pro rata share. Nobody's shortchanged in that process, but there is the ability to maybe keep some part of that family together that has that generational history.
Yeah, that's a great example. I actually helped a guy with that a few months ago, where he had inherited a house, I think from his grandfather, and his grandfather had willed it to him, but there was a lot of, debts owed. And I said, well, you can buy this house from your grandfather's estate. You're going to have to pay fair market value, and you'll have to go get a mortgage, but you can absolutely go buy this house from the estate and pay the estate. And then it's yours, but I mean, you can't get it for like a super good deal. You're going to have to pay, whatever the appraised value is. And he's like, oh, well, yeah, I'll do that because I really love this house. And he was living in the house and he didn't want to move, So
Yep.
I helped him get with a mortgage guy. I said, call my mortgage guy. He'll get you hooked up with a mortgage. And then you can just do a purchase and sale agreement between you and the estate and present it to the probate court with the appraisal and all that stuff. And the judge approved it and all was good. So, Yep, definitely. Awesome. And in terms of talking about appraisals, are estate appraisals required in Arizona, or is that sort of a case-by-case basis, or are there waivers or that sort of thing? Some states have that, some don't.
I always recommend getting an appraisal. I always think that an appraisal is helpful because going back and getting that information is more difficult than getting the information up front. But if there's, like, let's say that there's one parent, two children, and both of them are inheriting a house and they want to agree on a price for that house, I'm not going to require them to go get an appraisal for them to enter into this agreement. The reason why I would say to get an appraisal, though, is because Arizona does have a step up in basis, meaning that when you inherit a property, you inherit that property at the value it is as of the date of death. And so you want to make sure that you're protected when you go to sell that property. But if they're just unwilling to get the appraisal, and I give them the advice, there's no requirement that they have to get that done, especially when you can come to an agreement as a family. So it really depends, but 98% of the time, I recommend get an appraisal. It's always helpful.
Cool. Awesome. And obviously, getting an appraisal also helps from the therapy aspect of families fighting over things. And there's no, I've seen it where Uncle Bob thinks the house is worth $1 million. I'm like, Uncle Bob, the house is worth like 200 on a good day.
Get out your checkbook and buy it, Uncle Bob.
Yeah.
Yes.
Right.
Yeah.
You can have it for 800.
And Uncle Bob's the one that doesn't want to sign off on everything. And everyone's like, come on, Uncle Bob, like this house isn't worth what you think it's worth. And then it sits in this stalemate for months where like doesn't go anywhere. And finally, one day he comes around and says, okay, yeah, all right. But it's like, okay, 2 years has passed. And,
Yeah.
So yeah, that's crazy. And I'm sure you have to put your therapist hat on sometimes and deal with infighting in families. Like, do you have a piece of advice for a family that is disagreeing over things? Like I don't know, do you have a piece of advice for them to like get over that hurdle?
I have some advice. David, I don't know if you want to take this first.
I leave that to you. That's why I don't host this stuff anymore.
Okay.
Everybody's happy when they leave my office.
Yeah, I deal with a lot of unhappy people. So number one, if it's not a big deal, let it go. If it's not a big deal, let it go. If financially it's not a big deal, if sentimentally it's not a big deal, let it go. And if the thing that you're fighting over costs less than my hourly rate, and you're going to pay me to fight over this thing, you really need to ask yourself if it's worth it, number one. And then number two, if the family just can't get along, I'm happy to be that point of contact. I'm happy to have everything go in writing. I'm happy to send out letters, emails, advising everyone of what's going on. I'm happy to be the bad guy. So if you can't get your brother to cooperate or move out of the residence, I'm happy to write him a letter. Explaining the process to everybody. If you are just not comfortable reaching out to these family members, I'm happy to be that point of contact.
That's great.
Elizabeth raises an excellent point about her hourly rate versus the cost of getting your result. And one thing I always tell people, the question always comes up, can I sue this person for X? Yeah. If you pay a $279 court filing fee in Arizona, you can sue anyone for anything. Yep. And you can probably find a lawyer who will always take your money. But whether you have a good claim, a valid claim, a stupid claim, it's really important to work with somebody who cares about you first and has a business that's sustainable for themselves so they don't have to take crappy cases and milk people along that road of exploitation.
Absolutely.
One of the reasons Elizabeth and I work so well together because we approach our businesses in a very similar way. Ultimately, we're here to serve people and serve them well.
Yep. And I tell my team that all day, every day. I said, guys, we have to make sure that we're doing the right thing, right? Because the last thing I want, someone can sue me and I might be right? I may have done everything right, but I still have to pay money to my attorney to defend myself and protect myself in that suit to prove that I did something right. So let's make sure that we don't ruffle any feathers. We don't piss any people off. Sometimes there was a deal I did a few years ago where these people were just crazy. And there was a plumbing issue that came up with this house after closing. And I could have easily said, you know what? That's your problem, not mine. But I said, I bet you this lady would sue me if I don't fix this. So I'm going to pay the $2,000 today and I'm going to send a plumber over to that house. I'm going to fix that issue. I didn't have to do it, right? But I did it because I was like, no, I bet she would probably sue me because she's that crazy. Like, and I would have had to pay to defend myself, whether I was right or wrong. So,
sure.
So guys, this is probably in your realm, David. Like, I'm sure you deal with people doing estate planning and mom's got to go into assisted living, right? Mm-hmm. Is there, in Arizona, I know in Georgia we have this requirement, but in Arizona, do you have to sell a house in order to qualify for like state Medicaid paid assisted living? Is that a requirement there like it is here?
It's not a requirement. The state assisted living, it's a subset of Medicaid, the healthcare system for the poor, and that's administered at the state level, which in Arizona we call that ALTEX, for Arizona Long-Term Care System. Mm-hmm. One doesn't have to do that, but there's a very specific approach to applying for that aid and keeping the home. There are several very technical requirements to do that, so we always recommend getting someone who understands specifically that aspect of ALTEX in the Arizona Long-Term Care System. There are a lot of attorneys who do estate planning in Arizona. I would say a handful will focus and actually understand the very technical rules to ALTEX. Along with that, I would also say that that kind of McDonald's approach we spoke about towards the beginning of your show, with regard to you need to have a revocable living trust, you must have a revocable living trust, et cetera, et cetera. It's very important to get a plan that's appropriate for you because if you put assets into a trust because you got the best price after talking with 5 different attorneys and the independent paralegal and document preparer, and you went with the cheapest one, what you might have done is actually made yourself ineligible for any Altex or Medicaid assistance from the government, because assets that are in trust actually disqualify you from receiving any government benefits. So that's one very important reason why sometimes we're not only not using revocable living trusts, but in the case of married couples, we're actually trying to force probates, because that's one way of preserving assets if you've done your estate plan with an attorney that understands that underlying technical process within.
I gotcha. Yeah. So definitely, so you would recommend them speaking with an attorney who's very knowledgeable in the Altex world that they're going to go down.
Absolutely.
Great. Awesome. Because we find that from time to time, right? Maybe we'll get a house and someone called us and say, hey, dad died, but mom's still alive, but we're putting her in assisted living and we need to sell mom's house because it's $10,000 a month or whatever for assisted living. And, or we go to sell a house after the fact and mom was in assisted living and now Medicaid has tacked on liens to this property. And they're like, what do you mean there's like $50,000 in liens on this house? Like what?
There's a process called estate recovery, and it's very state specific. Arizona has estate recovery for most type of assets, not all. If someone does have to go into assisted living, there is a box you check on the Altex application. Do I have an intent to return to my home? Whether you have an intent or not, most people we recommend tick that box, because ethically speaking, on behalf of that person, you just don't know. But also that does enable that asset to be addressed in other types of legal mechanisms to potentially save it from estate recovery. In Arizona right now, they don't do estate recovery for something called a beneficiary deed or transfer on death deed. That's an administrative decision the state of Arizona has made. It's subject to change at any time. They could change it tomorrow and there's not going to be any notice. That change will just appear. But a beneficiary deed, historically, Arizona hasn't gone after home assets that transfer with a beneficiary deed. So there are ways to preserve assets for the rest of the family when mom ultimately does pass away, even if she's been on state assistance.
Okay, awesome, cool. We're getting close to the end of time here. This is a question for you, David. What would you say for a real estate professional, someone myself, maybe an agent, investor, someone like that, what would you say is kind of a good, better, best approach for somebody to get their estate planning in order? Where should they start? What's the Cadillac versus you mentioned you have 14 different chassis that you put people in?
7 for the individuals, 7 for the married couple, and they parallel. So maybe you want to say it's only 7.
Okay.
But we kind of look at the complexity of one's estate. If you have very limited assets, you're not so much concerned about directing where stuff goes at the back end, but you're really more concerned about deciding who's going to help you make decisions when you're alive and healthy. So at the lower end of that estate, you're probably looking at between $1,500 and $2,000 to have something customized just for you. If you want to look at more comprehensive will-based planning and trust-based planning, where there might be some assets, and you're looking that after that death or after the second death in the case of a married couple, the control of those assets is reserved until maybe the youngest child turns 25, something like that. That you're looking maybe $3,500 to $4,000 for a fully comprehensive plan that protects children, protects against incapacity of disabled children, has that what-if planning built in case one of the parents needs assistance later on from the government. So one parent, that maybe the healthy spouse isn't just writing checks until the needy spouse passes away. So we're looking at $3,000 to $4,000, something like that. And then there's another level where you're worried about intergenerational wealth protection. I say that once your stuff becomes your children's stuff, it's subject to your children's problems. And as Elizabeth has stated earlier in our call today, you don't always know what someone's problems are. The big 3 that we find are debts, divorce, and disability. Kind of the next level of those is bankruptcy, tax problems, and lawsuits. And then there's the other hazards of life. So if one wants to pass stuff to the next generation and kind of put an insurance wrapper around that, you can pass things in something called a beneficiary asset protection trust. So your property remains your property in a trust that you create for your children. Now, your children are the beneficiaries of the trust, and they're the trustees. They have full control, and they can lose everything they have to their problems. But if you're working with an attorney who knows how to create these, you can pass stuff to your children that they can never lose because of their problems. And those you're really looking more in the $5,000 to $7,000 range to put a comprehensive package together.
That's very reasonable. I mean, the first two are almost on par with what Elizabeth would charge after the fact, right?
100%. Yeah.
Yeah. So you're either going to pay now or you're going to pay later. You choose, right? Like, but it's better to do it up front so you don't have to deal with the headache after the fact, right?
And it's absolutely that. But in addition, it's if you work and save and plan for 40, 50, 60 years, do you really want to leave that all to chance? When for a few $1,000s, maybe your vacation to Hawaii a few years ago, you can create something that's going to last certainly your lifetime and then sometimes multi-generations. In Arizona, we can do these beneficiary asset protection trusts for 500 years that you can protect and preserve and assist your family.
That's awesome. Love it. Well, hey guys, we've kind of run out of time today. I really appreciate your time. If somebody is interested in their area, in Arizona, maybe the greater Phoenix area or whatever, wants to work with you guys, what is the best way for them to kind of get a hold of you?
For us, just go to Google. Google, I'll move over, Citadel Law Firm, or our website is clfusa.com, Charlie Lima Frank, USA.com.
And to kind of recap, you guys, David, you just sort of handle the pre-death, the estate planning in that piece of it, correct?
We do pre-death work for people who are competent to make their own decisions. That's correct.
Got it. So if someone is suffering from dementia or something like that, you're going to probably hand them over to Elizabeth to do a guardian, something like that.
That's absolutely right. Elizabeth is an off-counsel attorney associated with my firm, and I am an off-counsel attorney associated with her firm. You can really call either of our offices, and our intake staff will assess your case, assess your needs, and they'll direct you to either one of us, depending on what you need.
Okay, cool. And Elizabeth, to get in touch with you from the post-probate perspective, obviously, like David said, they could reach out to Citadel and they would get you in touch with them. But is there another better way to get in touch with you if they're interested in working with you?
Yeah. You can find all of my information at Copper Wren Law, COPPERWREN Law, Copper Wren Law. And I handle all kinds of issues. So if you're dealing with a situation where you're an agent on behalf of a family member, maybe you're acting with a power of attorney and you need advice in that kind of general area, I can help with that. We do trust administrations for people who are still living, incapacitated. Maybe they do still have some capacity, but they've asked a family member to step in. Certainly, if you need legal advice, we're happy to assist in those. So some of our cases are in the courts, some of them are out of the courts, but I deal with incapacity, people who are acting on behalf of their loved ones, family members, and then after death situations with probates and trust admins.
Awesome. Well, hey guys, I really appreciate you guys coming on. This was like so much information, so full of just super useful information for everybody in the state of Arizona. So I appreciate you guys coming on, and I'm sure you're going to go sit in the air conditioning the rest of the day because it's probably ridiculously hot there.
It was only 117 yesterday.
Oh, that's it?
Yeah.
Yeah. It's a dry heat.
It's 94 and like 80% humidity here today in Georgia. So it's a different kind of heat here. So awesome. Well, thanks for coming on, guys. I really appreciate your time. And we'll put your contact information in the show notes if anybody wants to get a hold of you. Guys, I appreciate you checking out the podcast again. Like I mentioned in other episodes and earlier on, if you're a real estate professional, you're interested in getting in the probate niche, we have a done-for-you marketing package where we will run all of your probate marketing. Been doing it for years. I'm an expert at this. And if you ever need a professional, if you're in the state of Arizona, call Elizabeth or David. They can help you out. So thanks again for watching the show. Talk to you later. Bye-bye.